All right, so we are going to discuss CCI versus Bharti Airtel case today. The PPT number 4 that I have already sent you. Yeah, so we are continuing with the interface of sectoral regulators, basically the same matter that we started in the last class, that whenever there is any subject matter that overlaps with the Competition Act as well as other legislation, so which will be the proper legislation to deal with the matter, how will a balance be struck between the Competition Act as well as the other legislations. So in this particular case, so the case that we discussed in the last class, Ericsson versus CCI. So in that case, we looked into the overlapping between the Patent Act we discussed the Patent Act and the Competition Act. In this particular case, we are going to discuss the overlapping of issues that may arise in telecom matters. And whenever there is such an overlapping between the Telecom Regulatory Authority of India Act and the Competition Act, how will the balance be struck? So in this particular case, if you see the screen is the PPT is available in your. You can see the PPT on your screens, right?
Yes, ma'am.
Yeah. Okay. So the issue in this particular case is to understand what is the scope of the powers of Competition Commission of India whenever there is any matter pertaining to the telecom sector. So that is in respect of companies in the telecom industry providing telecom services. So we have to understand vis-a-vis the scope of the powers under the Telecom Regulatory Authority of India. So the issue is in an overlapping matter between the Telecom Regulatory Authority of India and competition law, which will be the authority in what kind of subject matters which authority will have jurisdiction. So let us look into the facts of this particular case. So the facts of this case, RGIL is Reliance Jio India Limited. So Reliance Jio India Limited wrote three separate letters to three other telecom operators, that is Airtel, Vodafone and Idea, requesting them that they need to augment their point of interconnection for access for national long distance and for international long distance services, as according to Reliance Jio, the capacity which was provided by these three telecom companies, Airtel, Vodafone and Idea, was not enough, and it was leading to huge congestion resulting in call failures on its network. So you have to understand that when you are a telecom operator, you need to provide interconnectivity to the subscribers of other telecom services. Otherwise, a subscriber of Airtel will not be able to make calls or will not be able to send data from their phones to, for example, to a subscriber of Vodafone or to a subscriber of Reliance Jio. So these kind of interconnectivity between the telecom operators is much required. Now, Reliance Jio in this particular point is alleging that it wrote letters to these three telecom operators that they need to increase their point of interconnection to provide them better access, because whenever the subscribers of Reliance Jio was trying to access the subscribers of the other telecom operators like Airtel, Vodafone and Idea, it was relating to call failures, and most of the time when calls were made, data were to be transmitted, there was huge network congestion. Now, according to Reliance Jio, the next point, they said that these three telecom companies completely ignored their request to augment the point of interconnection, and hence they had to request the Telecom Regulatory Authority of India to actually intervene in the matter and ask these three companies to augment their interconnectivity capacity. Now, after it got the request from Reliance Jio, also sent letters to these three telecom operators saying that as per the request of Reliance Jio, they need to augment their point of interconnection, which means they have to provide better interconnectivity to Reliance Jio in this particular, as per the request which is made by Reliance Jio. So we need to look into what is the response. So the last point, TRAI wrote letters to the three telecom operators. What is the response to the letters written by TRAI to these three telecom operators? So the response is, Idea completely denied that there has been any delay in augmentation of the interconnection, and they said that we are fully willing to support Reliance Jio, and we have already instructed our teams to augment the point of interconnection. Airtel said the same thing, that the work will be undertaken, and on the basis of the traffic trends post their commercial launch. Now Reliance Jio doesn't seem to be very happy with the responses. That Idea and Airtel said that we are starting the work, or we have already seen to it that the point of interconnection is augmented. But Reliance Jio was not at all happy with the responses, because they felt that they were saying one thing but not doing it. On the other hand, there is an association of the telecom operators in India, COAI. It is Cellular Operators Association of India. Now they intervened in this particular matter before the trial, and they sent a letter to the trial saying that Reliance Jio was providing free services to millions of users. So we already know about this problem. The Reliance Jio was giving free service to millions of subscribers in India under the guise of testing. So they said that we are just testing it, and on the guise of testing, we were actually providing free services to millions of users. And as per the Association of the Telecom Operators of India, this giving free service to millions of users under the guise of testing was actually leading to choking of the networks. It was leading to huge congestion. So they said, if at all somebody has to be blamed, it is Reliance Jio itself who has to be blamed, because they are providing free services which are completely leading to congestion in all networks. Now the trial's role, what did TRAI do in this particular case? So TRAI tried to facilitate a meeting between these four parties, that is Airtel, Vodafone, Idea, along with Reliance Jio. They facilitated a meeting, and they asked them to sort out their problems and resolve their differences for the interest of the consumers. However, when they felt that the meetings did not go well with these four parties together, TRAI decided to give its recommendation, because it's a recommendatory body. Now, TRAI in its recommendation said that Airtel and other service providers, that is Idea and Vodafone, have jointly, through their association COAI, has declined point of interconnection, to Reliance Jio, and this is against the license conditions which are given under the Telecom Regulatory Authority of India. So when in India, under the Telecom Regulatory Authority Act, when licenses are procured by telecom operators, they have to fulfill certain terms and conditions. And one of the terms and conditions is to provide good interconnectivity to other telecom service providers. So TRAI in this case felt that these three telecom operators, Airtel, Vodafone, and Idea, were willfully violating the license condition, and hence they felt that so the TRAI authority has taken necessary steps to ensure effective interconnection between Airtel and Reliance Jio, but they felt that Airtel was non-compliant of the terms and conditions of license, and they were doing it with an ulterior motive to basically stifle the competition, and TRAI said that it is completely anti-consumer in nature. Hence, TRAI recommended that there should be penalty imposed on these three telecom operators, that is Airtel, Vodafone, and Idea, because they failed to conform to the norms and regulations which are set up by the Telecom Regulatory Authority of India. Now, so this was TRAI's role. What did TRAI try to do? Try to facilitate a meeting between the parties, but the parties did not come to any kind of decision or any kind of solution. Hence, TRAI had to go ahead and give its recommendation. It's a recommendatory body. They felt that all these three telecom operators were willfully disobeying the terms and conditions under the TRAI Act, because they wanted to stifle the competition which was coming from Reliance Jio, and they felt that this action was entirely anti-consumer in nature. Hence, they imposed penalty. They recommended that penalty should be imposed by the three telecom operators because they failed to adhere to the TRAI norms and regulations. Moving on, against this TRAI's decision that penalty should be the recommended penalty against the three telecom operators, there was writ petition filed against the TRAI's decision. These writ petitions obviously were filed by these three telecom operators, that is Vodafone, Airtel, and Idea. that the recommendation of TRI was entirely wrong and they were not at fault. So they preferred a writ petition. Now, how did the matter come to the CCI? So in the meantime, TRI's decision definitely went in favor of Reliance Jio, but they knew that already a petition was filed against the decision of TRI before the courts by the Three Telecom Authority. Now, Reliance Jio also didn't want to sit idle, and they filed the matter before the Competition Commission of India. They approached the Competition Commission of India. Now, the moment the matter comes before the Competition Commission of India, the Competition Commission of India does a preliminary inquiry to figure out whether there is a prima facie matter or not. And in this particular case, after looking into the facts, they found that there is a prima facie matter, and hence they asked the Director General of the competition to examine the matter, which means that CCI admitted that probably there are matters which might indicate that these three telecom operators have violated the provisions of the competition law, and hence asked the DG to examine the matter. Now, this particular order of the CCI asking the DG to investigate against them did not go well with Airtel, Vodafone and Idea, because they felt that CCI did not have the jurisdiction to try this matter, because this was a matter pertaining to the Telecom Regulatory Authority of India Act. Hence, they approached to the Bombay High Court, questioning the very jurisdiction of the Competition Commission of India in this particular case. Clear, everyone, till this point? The facts? Yes?
Yes.
All right. Now, what did the Bombay High Court have to say in this particular matter with regard to CCI's jurisdiction? Whether in this particular matter, TRI only had the jurisdiction, or did CCI also have the jurisdiction to try this particular case? Now, the Bombay High Court's decision was that so far as contracts, etc., which were regulated by TRIs are concerned, in the first instance, it is the authority under the TRI Act which has to decide these questions. Once there is a determination of the rights and obligations of these licenses under the TRI Act, which provides an information that the parties might have done something anti-competitive, only then the CCI gets jurisdiction to deal with the case. So this is a very interesting decision, and please look into it very closely, what the Bombay High Court had to say in this matter. The Bombay High Court said that look into the facts of this case. What is the problem? What is the main allegation by Reliance Jio? Reliance Jio's main allegation is that there are certain terms and conditions you have to fulfill when you are given a license to operate telecom services in India. So when Airtel, when Vodafone, when Idea procured these licenses to carry on telecom services in India, it was understood that they have to fulfill these terms and conditions. One of the terms and conditions is to provide point of interconnectivity to the other telecom service provider. Now, their main allegation was these three companies were not fulfilling their license terms and conditions. So Bombay High Court said that in the first instance, because this is a matter pertaining to TRI's license, it is the authority under the TRI Act which has to decide this question. So it should be the TRI authority first who has to decide this matter. Now, when the TRI authorities, in the second point, when they are deciding the matter, they feel that these three telecom operators have, done something in a concerted manner. That they all together decided that we will not increase our interconnectivity, we will not augment our interconnectivity to Reliance Jio. When they did it in a concerted manner, there were evidences which were anti-competitive in nature. The Bombay High Court said it is only after that the Competition Commission of India will get jurisdiction to deal with the matters pertaining to anti-competitive practices. So they said first TRI. If TRI says that there is some anti-competitive elements involved in this particular case, then the CCI gets the jurisdiction to deal with the case. So court of first instance, because it's a matter pertaining to license, the TRI has to deal with it first. However, this particular decision of Bombay High Court obviously did not go well with Reliance Jio and CCI. CCI was not happy because they felt that they had jurisdiction to try the matter. Bombay High Court said no, first try authority will deal with the matter. CCI was not happy. Reliance Jio was not happy because they felt that no, CCI should have the jurisdiction to deal with this matter, because there are two matters involved here. One is definitely license under the Tri-Act, but also cartelization in between these three telecom operators. With regard to cartelization, it is the Competition Commission of India which has jurisdiction to deal with this case. Now, because they both were not happy, they filed special leave petition before the Supreme Court. So Reliance Jio and CCI, not happy with the Bombay High Court decision, filed special leave petitions before the Supreme Court. And the decision that we are going to discuss is the Supreme Court's decision with regard to the sectoral regulators, that is TRI versus Competition Commission of India. Now, what we have to look is the decision of the Supreme Court. Certain important pointers. Please look into the screen. So, in order to ensure, the Supreme Court says, smooth interconnectivity between different telecom operators, a consumer who is a subscriber of a mobile phone of one service provider, for example, Vodafone, wants to make call to a mobile phone of his friend which is provided by another service provider, say Idea Cellular. The unified competition licenses put an obligation on all these licensees to interconnect with each other on the point of interconnectivity. Such interconnectivity of point of interconnection is subject to compliance of the regulations, directions issued by TRI. Something that I just explained. Suppose I am a subscriber of one service provider, Vodafone. I'm a subscriber of Vodafone and I want to make a phone call to a mobile phone of my friend, and my friend uses Idea Cellular. So until and unless Vodafone and Idea Cellular provides interconnectivity to each other, I will definitely not be able to call my friend, because we both don't have the same services. We both are not the subscribers of Vodafone. We are not both subscribers, the subscriber of Idea. I am the subscriber of Vodafone. My friend is the subscriber of Idea. So until and unless these two telecom providers don't provide interconnectivity, I will not be able to call my friend. My friend won't be able to call me. Hence, in order to deal with these kind of concerns, this is the interconnectivity of POI, interconnectivity of the services of different telecom providers is mandatory, and it is subject to compliance of the regulations direction issued by TRI, that one telecom operator has to provide point of interconnection to another telecom service provider. Continuing. Now, the licenses, what are the conditions of the license? The license which are granted to telecom operators for continuing their services in India. So there are certain conditions we have to look into. What are the conditions? First condition is they have to give quality of service. The service that they are providing has to be of quality. They cannot provide inferior quality of service to its subscribers. So if they're providing very inferior quality service to its subscriber, this is against the TRI licensing conditions. The next one which we need to understand for the case in hand is to render effective services. It is mandatory for the licensee. Who is the licensee here? Telecom service providers like Jio, Airtel, Vodafone, Idea. They are all licensee. The license is given by the TRI authorities, so they are the licensee. Now, in order to render effective services, it is mandatory for the licensee, the telecom service providers, to provide point of interconnections to all eligible telecom service providers. So, one of the conditions is that they mandatorily have to provide point of interconnection to the other telecom service providers. If they don't do it, it means that they are violating the terms and conditions under which they were given the right to operate telecom services in India. So this is the main allegation in this particular case, that the three telecom operators were violating this mandatory condition and was not providing POI, point of interconnection, to Reliance Jio. So keeping in mind this, the background of this particular case, let us look into what is the core issue in this particular case. The core issue is the powers of the Telecom Authority, Regulatory Authority of India vis-a-vis competition matters. Now, first of all, the Supreme Court here looks into what is the power of the Telecom Regulatory Authority of India under the TRI Act. What are the important powers that they have? We don't have to necessarily look into all the important powers of the TRI, but for the purpose of the case, for our case, I have highlighted the important powers in red. So just read or look into these pointers which are written in red color. So this is enough for the purpose of the case that we are reading right now. One of the important powers of TRI is to see that there is compliance of the license condition by all service providers. So this is the main bone of contention in this case, that the 3 telecom providers were not complying with the license conditions, which has to be mandatorily provided by all the service providers. Secondly, protection of interests of the consumers of telecommunication service. So obviously, every time I am a Reliance Jio subscriber, every time I want to call my friend who has a subscription of Airtel, and every time there is a network congestion, I'm not able to transmit data. I have to send my friends some important documents. I'm not able to send those important documents. So obviously, it is detrimental to the interest of the consumers. It is detrimental to my interest. I am the Reliance Jio consumer as well as my friend also, because my friend is an Airtel consumer. So in this particular case, if you look into the last 2 pointers, in this particular case, the dispute which is raised by Reliance Jio specifically touches these areas, that it is a violation of the license agreement, and this is detrimental to the interest of the consumers of telecom services. And the main grievance which is raised is that these telecom companies have not given points of interconnection as per the license condition, and because they are not providing the POIs, it is resulting in non-compliance and have failed to ensure interstate technical compatibility thereby. Not only Reliance Jio has raised this dispute, it has even approached TRI for settlement of this particular dispute that they have with the other 3 telecom operators. Moving on. So far you have understood the case, everyone? Yes? You're getting the case, everyone?
Yes, ma'am.
Okay. Okay, so what is the arguments of the parties? The arguments of these 3 telecom providers against in the Supreme Court. What did they have to say against Reliance Jio? So this the slide in front of you is the arguments by these 3 telecom operators against Reliance Jio. First of all, they said, look at the points at least which are highlighted in red. So they said immediately on commercial launch of Reliance Jio, they said that we will have 22 million subscriber base. So they said it's a huge number, right? Suddenly we have to augment our point of interconnectivity because Reliance Jio is saying that our consumer base will be 22 million. So it's not easy, number one. So they're saying that test customers are not supposed to be subscribers. So during testing time itself, when Reliance Jio said that we are just testing our connection, they were giving free services to all these subscribers. It was leading to congestion, and they said test customers are not supposed to be subscribers. And if there's point of congestion and they are test subscribers, so this is nothing, you cannot say that this is a violation of the license provisions under the TRI Act. You are still on the testing phase and you are yet to come on the commercial scale, so you cannot directly allege us that we have violated the conditions under the TRI Act. Now these are some of the concerns which are raised. Further, so they're saying TRI is constituted as an expert regulatory body which governs telecom matters. So TRI is the appropriate body to deal with telecom sector matters. And the aforesaid aspect of the dispute are to be decided by TRI in the first instance. So these 3 companies are saying that TRI is the appropriate authority because it's the authority under the telecom sector. So these are so the TRI should be held to be the court of first instance in this particular case. Now, after all, they are saying Reliance Jio's main grievance is what? The Reliance Jio's main grievance is interconnectivity is not provided by us. as per the license which is granted to these three telecom authorities. So Reliance Jio's main grievance is we are not getting proper connectivity from these three telecom operators as per the regulations under the TRI-Act. These three telecom operators has to provide us point of interconnectivity. They are violating the TRI conditions. So interconnectivity and licensing is the issue here. There is no other issue involved here. And the matter pertains to telecom sector. Hence, TRI is the expert regulatory body to deal with the case. Okay. Now we have to look into the Supreme Court's decision, what the Supreme Court has to say. So the Supreme Court says that first, in this particular case, these three telecom operators, Airtel, Idea, and Vodafone, has said that CCI does not have the jurisdiction to look into the matter. It is only the TRI who has to look into the matter. So first, we have to deal with the jurisdictional facts in the present matter, under which authority the matter should be decided, and then the question will arise whether there was any kind of concerted agreement between the telecom operators, and did the collective body of telecom operators, COAI, Cellular Operators Association of India, supported these three telecom operators in their cartelization process. So the Supreme Court is saying first is the jurisdiction in this particular matter pertaining to license of operation of telecom services in India. The jurisdiction of this case is with TRI Act, under the TRI Act, or this case can come under the CCI Act. So first of all, we decide on the jurisdictional facts, and after the jurisdictional facts comes the question of cartelization. Did they do it individually or did they do it in a collective matter? And if they have done it in a collective manner, so then comes the question, will CCI deal with this matter or not? Now, the second point, it would be at that stage, in the second stage, then the CCI can look into the question whether violation of the TRI Act amounts to abuse of dominance or anti-competitive agreements or not. So once the jurisdictional facts basing on the licensing under the TRI Act is decided, then comes the question, did this telecom operator do it in a concerted manner? Did they abuse their dominant position? And only then will the CCI get to decide whether Section 3 and Section 4 of the competition law is violated or not. There is another reason the Supreme Court said that we have to do it, because suppose we allow both the parties to continue together, the TRI Act continues together, the CCI continues together. At the end of the day, TRI Act says that no, these three telecom operators have decided not to augment their point of interconnection individually. On the other hand, the CCI comes to a conclusion, no, we feel that they have done it in a concerted manner. So two completely different conflicting situations given by two authorities. Which one to follow, which one to decline. So the Supreme Court is saying we should see that the two sectoral regulators do not arrive at conflicting views. We have to see that this kind of a situation needs to be avoided. Hence, first deal with the jurisdictional facts. Licensing matter, TRI will decide. TRI feels they have not done it individually, they have done it in a concerted manner, or there are hints that they have done it in a concerted manner. Then CCI decides whether there is violation of Section 3 or Section 4 of the competition law. Moving on, important issue, whether TRI has the exclusive jurisdiction to deal with matters involving anti-competitive practices to the exclusion of CCI because of the reason that the matter pertains to telecom sector. Very important issue. If there is a matter pertaining to telecom sector, thus Telecom Regulatory Authority of India has the exclusive jurisdiction to deal with the matter, and they can say that CCI, please you keep out of this. Because this is matter relating to telecom sector, we only have the exclusive jurisdiction, you don't have the jurisdiction. Can this kind of a position be acceptable is the issue right now. Now, so you have to understand in the points that I have mentioned in the slide, there was an argument that TRI is a special legislation and Competition Act is a general legislation. And in case of conflict between a special legislation and a general legislation, it is the special legislation which gets predominance over the general legislation. Something that we even discussed in the previous case in the last lecture day before yesterday. It is Patent Act a special legislation or Competition Act a special legislation. Now, in this particular case, the court is saying that apparently it might seem to be a very attractive supposition that TRI is a special legislation, competition law is a general legislation, hence TRI Act will have predominance over Competition Act. On the face of it, it looks very attractive. But the court says that the matter cannot be examined but just by looking into the TRI Act alone. So you cannot just look into the TRI Act and decide whether CCI has a jurisdiction or not. You have to compare both the regimes of the TRI as well as the Competition Commission of India, understand the purposes behind the two legislations in order to come to a conclusion on a case-to-case manner whether TRI has jurisdiction or CCI has jurisdiction or both together has jurisdiction to deal with the case. Now, the next slide, look into at least the points which I have highlighted in red. So the CCI therefore is to determine whether the conduct of the parties was unilateral or it was on a collective action based on an agreement. Now, appellants are right in their submission that CCI is supposed to find out whether the operators were acting in concert and forming a cartel in order to block Reliance Jio from entering into the market, which is a violation, of course, of Section 3 of anti-competitive agreement. So they are saying that CCI definitely has to look into whether they were acting in concert and forming a cartelization or not. So the contention of the three telecom regulatory authority, that is telecom regulatory operators, that is Airtel, Idea and Vodafone, is wrong so far as they are saying that jurisdiction of CCI is totally ousted because this is a telecom sector matter. So Supreme Court is very clear as to the answer to this particular issue. Whether in case of telecom sector matters, TRI has exclusive jurisdiction, which means CCI will not have exclusive jurisdiction. The Supreme Court says no, this is not the case. Just we cannot agree with the three telecom operators. The jurisdiction of CCI is totally ousted out. Appellants, that is Reliance Jio, is correct that CCI is supposed to find out whether these operators acted in concert, and if they have acted in concert, formed a cartelization, it is definitely a violation of Section 3 of the competition law. Hence, the jurisdiction of CCI cannot be ousted in this matter just because it's a matter pertaining to telecom sector. So we understand this particular fact with regard to interface of sectoral regulators. If there is a matter pertaining to telecom sector and there is an overlapping between the TRI and the CCI, you cannot say that TRI has no the CCI has no jurisdiction. The Supreme Court has said that you cannot give a blanket statement that CCI has no jurisdiction. CCI might have jurisdiction if the matter involves cartelization or the matter involves abuse of dominant position. Moving on. So, however, the balance has to be maintained because definitely there is an overlapping matter. CCI will have definitely the jurisdiction to try the matter. They cannot be ousted out, but you need to strike a balance between the two because you don't want both the sectoral regulator to come to two different decisions. So the question is, how do you maintain the balance? You can only maintain the balance by permitting Telecom Regulatory Authority as the court of first instance to deal with the licensing provision. The matter bone of contention, licensing conditions under TRI. Let Telecom Regulatory Authority of India first try with the matter pertaining to the jurisdictional issue with regard to licensing of telecom operators. Then, once that exercise is done by TRI, they come with the findings. Anybody saying something? Okay, so once the CCI TRI says that yes, they feel that the telecom operators have indulged into anti-competitive practices, that very moment from TRI the matter goes to the CCI. First, TRI will look into telecom sector matters pertaining to especially licensing and all, like the facts of this particular case. Once, when they're giving their findings, TRI is giving their findings, they feel that there is anti-competitive practices involved in such case, then Competition Commission will get cognizance of the matter. So the last slide, promotion of competition and prevention of competitive behavior may not be high on the change of sectoral regulators, which makes it prone to regulatory capture. So you have to understand that the TRI will only look into certain subject matters. They will look into violation of their licensing agreement. They will look into whatever powers are given to them under the TRI Act. They are not supposed to look into matters pertaining to competition. This is not their jurisdiction. So the Supreme Court says, therefore, in our analysis does not bar the jurisdiction of the CCI altogether. So in matters of telecom sector, in matters pertaining to telecom sector, we give a decision that we are not taking away the jurisdiction of the CCI, but we are only pushing it to a later stage after TRI has taken a decision in the first place that yes, probably there is a violation of the licensing agreements, and it is not just one party who is violating the licensing condition, but they are violating the licensing conditions of TRI in a concerted manner. And the moment TRI says that, then the matter comes to CCI at a later stage, and the CCI get the cognizance of the matter. Right? Everybody? Yes?
Yes.
Yeah. Any questions? I have less than a minute. Yes?
No, ma'am. Thank you.
All right.